NACDL is the association of the nation's criminal defense bar.
Hello, everyone. My name is David Laufman. I'm a partner in the Washington, D.C. office of Wiggin and Dana, where I co-chair the firm's national security practice and am a member of its white collar and government investigations practice. I want to thank NACDL for hosting this webinar, and thanks to all of you for participating. We are recording this on April 10th, 2020, in the midst of the coronavirus lockdown. I hope all of you and your families are doing okay in the current circumstances. Let me begin with just a brief disclaimer. This presentation is a summary of legal principles. Nothing I'm about to tell you constitutes real legal advice. You can only get that by consulting with your own attorney. Everything being presented today is believed to be accurate at the time I'm delivering it. Certain laws, policies, enforcement practices could change. And what I'm telling you today doesn't purport to be a complete statement of all relevant issues. I come to this presentation from two perspectives. I come to the subject of the Foreign Agents Registration Act from two perspectives. First, from late 2014 to early 2018, I served as chief of the Counterintelligence and Export Control Section in the Justice Department's National Security Division, and in that capacity, I closely oversaw the Justice Department's administration and enforcement of FARA and the ramp up of FARA enforcement, which has continued to this day. Now back in private practice, I counsel parties on whether they have an obligation to register if they embark on certain activities, and if they register, how to comply with their disclosure obligations. And I also help companies and individuals troubleshoot any investigative activities by the Justice Department. Many of you are likely participating today because you've heard a lot about FARA in the last few years. That's because FARA, as illustrated by this slide, has been in the news quite a bit in the past few years, highlighted by, in particular, criminal cases involving individuals like Paul Manafort, Michael Flynn, Greg Craig, and others, and by an overall regulatory crackdown by the Justice Department. So to put it mildly, we're now living in an entirely new era of FARA enforcement. I like to say, in homage to the old Oldsmobile commercial, this is not your grandfather's Foreign Agent Registration Act. My goal today is to give you a broad overview of how FARA works and how it can apply to the clients you represent and to you in the law firms where you work when you are working on behalf of clients that may have FARA registration risk. We're going to start with an introduction to FARA, just to orient you, talk about things like key definitions and exemptions from registration, triggers for registration, FARA's applicability to lawyers, the obligations of registrants if you have to register, and enforcement. So let's get started with an overview of FARA. What is FARA? It's a federal law to establish transparency and disclosure regarding the conduct of certain activities in the United States on behalf of foreign governments and other foreign interests. And as I mentioned before, it's administered and enforced by the National Security Division of the U.S. Department of Justice. FARA itself is not a criminal statute. It's not specified in Title 18 of the United States Code, but there are criminal penalties for certain violations. FARA has a colorful history. It was enacted in 1938 in response to Nazi propaganda and subversive activities in the United States. And the legislative history, as illustrated by this quote from the Senate Foreign Relations Committee, kind of illustrates the environment in which it was enacted. You see this quote: "We believe that the spotlight of pitiless publicity will serve as a deterrent to the spread of pernicious propaganda." And that's what FARA was mostly about for the first few decades. It was to address perceived propaganda and subversive activities in the United States being carried out mostly by foreign governments. In the mid-1960s, Congress amended FARA to expand its scope to cover lobbying and consulting on behalf of foreign interests. And then again in 1995, FARA was amended as part of the enactment of the Lobbying Disclosure Act, and we'll talk more about how that works. What does it mean if you have to register? What are the core requirements of FARA? Well, the key is the definition of an agent of a foreign principal. That's the keystone of the statute. Unless you come within the definition of an agent of a foreign principal, you don't have an obligation to register. But if you are an agent of a foreign principal, then you have to do certain things. First, you have to register with the Justice Department within 10 days even of agreeing to become an agent and before performing any activities on behalf of that foreign principal, unless an exemption from registration applies. And we'll talk about exemptions in a few minutes. You also have to file disclosure statements, detailed disclosure statements with the Justice Department about every 6 months. And I should say that both the initial registration statement and these disclosure statements are uploaded onto a Department of Justice website, www.fara.gov, and they are available for public review and inspection. And inspected, indeed, they are by NGOs, by journalists, by people who take advantage of the public availability of this data to harvest it and sometimes write news stories about who has registered and who they're representing. You also have to include, if you are an agent of a foreign principal, a conspicuous statement disclosing your foreign agent relationship in what are deemed to be informational materials disseminated in the United States. And you have to file copies of informational materials disseminated within the United States with the Justice Department within 48 hours of their dissemination. In addition, you have to keep and preserve records, and those records are subject to inspection not only by the National Security Division, but by the FBI. Why should NACDL members care about FARA? Well, as I mentioned before, we are living in an era of increased FARA enforcement by the Department of Justice. Some of you may wind up representing parties who are subject to Department of Justice administrative inquiries or criminal investigation. Some of you have variegated practices. You don't only do criminal defense work. There could be other circumstances in which some of the work you perform on behalf of clients could come within the scope of FARA. And you yourselves could come within the scope of FARA. Clients need more compliance guidance than ever before in this enforcement era regarding the triggers for registration and required disclosures. As I mentioned before, there are potential criminal penalties for violations. And for some parties, there is perceived reputational risk to registration. Some companies and individuals believe that it's stigmatizing to register under FARA and be subject to characterization as a quote unquote foreign agent. And law firms and lawyers can also be subject to FARA registration and disclosure requirements. So we as lawyers and our firms have to be mindful of the triggers for our own FARA registration risk. Let's talk about what triggers the need to register. As I mentioned before, the key definition of it is agent of a foreign principal. You must come within that definition to trigger the registration requirements. And the basic elements are that you have to be acting as an agent, representative, employee, or servant of a foreign principal, or acting under the direction or control of a foreign principal. And you also have to be engaged in specific conduct identified within the statute, within the United States, on behalf of a foreign principal, either directly or through any other organization or individual. What does it mean to be a foreign principal? Well, it's broadly defined, more broadly than many people believe. It is essentially anyone and any entity outside of the United States. It's broadly defined to include not only foreign governments, but foreign political parties, a foreign business entity, so commercial entity, or any other non-governmental entity. It can mean an individual outside the United States. So in essence, the definition could apply to practically any client you may have outside of the United States. And what does government of a foreign country mean? Well, it's more broadly defined than a government. With the U.S. government or international recognition, it includes any person or a group of persons exercising sovereign or de facto or de jure political jurisdiction over any country or over any part of such country, and it can include any faction or body of insurgents within a country assuming to exercise government authority, whether such faction or body of insurgents has or has not been recognized by the guerrilla, but by the United States. So if hypothetically you were representing some guerrilla organization or some insurgent body within a region of a government that had no international recognition whatsoever, but it controlled, some territory or region within a foreign country, you would be representing a foreign principal because you would be representing a government of a foreign country. What relationship does the agent have to have for that foreign principal to come within the scope of the statute to trigger a registration requirement? Well, the agent has to be acting in any capacity at the order, request, or under the direction or control of a foreign principal or of a person, any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or major part by a foreign principal. That is to say, if you're acting as an agent of an agent. In a formal contract, a formal written agreement, for example, is not required to establish that degree of agency. It could be simply an oral understanding. The term control, you should also understand, is broadly defined. It means, it's deemed to include the possession, or the exercise of the power, directly or indirectly, to determine the policies or the activities of a person, whether through the ownership of voting rights by contract or otherwise. So control as defined could be merely the passive possession of that exercise to direct activities. So as I mentioned before, not only does the U.S. agent have to be acting at the direction or control or request, et cetera, of a foreign principal, but the agent has to also be engaged in conduct specified within the statute to come within the scope of FARA and have to register. Here are the categories broadly scoped that trigger registration: engaging in political activities as defined, acting as a public relations counsel or publicity agent, information services employee, or political consultant. You can see how some of these definitions have a somewhat archaic sound to them given the age of the statute. Collecting or dispensing money in the United States on behalf of a foreign principal. Representing the interests of a foreign principal before an agency or official of the U.S. government. That could mean emailing a government agency. It could mean seeking a meeting or taking a meeting with the U.S. government agency official, whether in the executive branch or in Congress. Now, FARA is focused on conduct occurring within the United States, but the Department of Justice could impose a registration requirement regarding activities for foreign principals outside of the United States that have or are intended to have effects within the United States. In other words, activities or conduct occurring outside the United States intended to influence the U.S. public or directed at the U.S. public. And when matters come to the Department of Justice's attention, say through a news article, they're likely to examine any nexus to the United States to evaluate whether FARA jurisdiction may apply. And the department recently has noted in an advisory opinion, an attorney general opinion dated around 1940, involving a request by the then Postmaster General to the Attorney General, Robert Jackson, asking whether Nazi propaganda mail coming into the United States from Germany could come within the scope of the statute. The Attorney General ruled that it could, and that FARA was implicated, and that's how broadly and expansively the department now views its authority. Recently, at a conference I co-chaired, the new chief of the FARA unit at the Department of Justice reaffirmed that point in the context, for example, of a public relations campaign directed from outside the United States at the United States. There's a low threshold to trigger registration. The obligation to register can be triggered by even the slightest activity in the United States in a specified area of conduct. And as I mentioned a few minutes ago, the mere agreement to engage within the U.S. in one of the specified types of activities on behalf of a foreign principal triggers the requirement to register under FARA within 10 days of that agreement and before performing activities. So let's come to these specified areas of conduct. Political activities is the most classic example of activities that triggers the statute. You can see how broadly it is defined here. Any activity that the person engaging in believes will, or that the person intends to, in any way influence any agency or official of the U.S. government or any section of the public within the United States with reference to formulating, adopting, or changing the domestic or foreign policies of the United States, or with reference to the political or public interests, policies, or relations of a government of a foreign country or a foreign political party. So even the intent to influence can trigger the application of this section if the activity has to do with the subject matter referenced in the definition. And here's an additional gloss on that part of the definition. What does it mean to be formulating, adopting, or changing U.S. policy? Well, it includes even any activity which seeks to maintain an existing domestic or foreign policy of the United States. So if you're lobbying, for example, to keep in place an existing policy as opposed to changing it, or as opposed to seeking an amendment to some bill, that can come within the definition of political activities. What political activities do not include is simply making a routine inquiry of a government official or employee concerning a current policy, or seeking administrative action in a matter where such policy is not in question. Here are some examples of political activities. This is not an exhaustive list. It's just meant to illustrate for you some examples. As I mentioned before, lobbying of Congress or the executive branch, other activities or communications intended to influence decision-making by government officials regarding the foreign principles, disseminating content in the United States that's aimed at influencing public opinion about the foreign principle. That can take many forms, including nowadays the use of social media, planting op-eds in key news media, and contacting think tanks or opinion leaders in the United States to influence them regarding views of a foreign principle. All those are examples of political activities. Keep in mind that contingent fees for political activities are prohibited by law under FARA. It is unlawful to be a party to any agreement with a foreign principal involving political activities where the amount or payment of the compensation fee or remuneration of the agent is contingent in whole or in part on the success of any such political activities. That bar does not apply to activities other than political activities, but be mindful of the prohibition for contingency fees with respect to political activities. Public Relations Counsel, again, this is among the coterie of somewhat archaic definitions. Basically, if you're involved in any way as lawyers in public relations activities on behalf of a foreign principal, there needs to be some FARA vetting analysis to assess whether you could have registration risk. Publicity agent, these are companies, typically individuals who are involved in the actual dissemination, technically, of content, informational materials on behalf of a foreign principal. This was a definition the Department of Justice found applicable to the activities of the United States of Russian media entities a couple of years ago. Same for the definition of information service employees, further technical definition applicable to parties who were involved in the broadcast or dissemination of information on behalf of a foreign principal within the United States. This also was a definition held applicable to the conduct and activities of RTTV America and its production arm, TNR Productions, as well as RIA Global, associated with the dissemination of content by Sputnik in the United States. So these are definitions the Department of Justice has recently used to hold parties subject to FARA's reach. I should also mention that information service employee and the previous definition, publicity agent, were bases on which the Department of Justice litigated the applicability of FARA to RM broadcasting in the Southern District of Florida when the department counterclaimed in response to a suit by RM Broadcasting asking for summary judgment that it was not subject to FARA. The department counterclaimed utilizing its authority to seek injunctive relief for the first time since 1991, and the court held in favor of the Department of Justice. Political consultant is another conduct trigger for the applicability of FARA. It is one of the more broadly worded and hence more nebulous and potentially troublesome definitions, since it involves simply providing advice, but the advice is supposedly tethered to domestic or foreign policies of the United States, or the political or public interest policies or relations of a foreign country or a foreign political party. It is so broadly worded that when Congress enacted amendments to FARA to add this definition, Congress explicitly made clear that it intended this conduct trigger to apply only in circumstances where the U.S. agent is engaged in political activities. The department hasn't made explicit its endorsement of that view, but there's some indication that it understands it is somewhat tethered to that constraint. So, as I mentioned before, if you are acting at the direction or control of foreign principal and you are engaged in one of those specified areas of conduct, you come within the definition of an agent of a foreign principal, and you have a duty to register unless you come within one of the specified statutory exemptions from registration. So let's talk about those exemptions now. These exemptions are available, as I say, to anyone who otherwise meets the definition of an agent of a foreign principal. If you can rely on an exemption, you don't have to register, but be mindful that by regulation, the party claiming an exemption bears the burden of proving the availability of the exemption if challenged by the department. Let's talk broadly about what these exemptions are. As you might expect, there's an exemption for accredited diplomatic or consular officers of foreign governments and their staff, officials of foreign governments engaged exclusively in activities deemed by the U.S. State Department as within the scope of their official duties. There are what are referred to as commercial exemptions, and these are important, particularly for lawyers representing business entities, foreign business entities. There's two prongs to this commercial exemption. One, for engaging only, and that is a qualifier, engaging only in private and non-political activities in furtherance of the bona fide trade or commerce of a foreign principal. And a second prong for engaging only in other activities not serving predominantly a foreign interest. We'll talk more about that in a minute. Additional exemptions involve engaging only in activities in furtherance of bona fide religious, scholastic, academic, or scientific pursuits or the fine arts. Certain persons whose foreign principal is a government of a foreign country, the defense of which the president deems vital to the defense of the United States. Those are set out in a separate statute. Legal representation in specified contexts. We'll talk more in detail about that. And certain persons and entities who have engaged in lobbying activities and who have registered with the U.S. House or the United States Senate under the Lobbying Disclosure Act. If you qualify for registering under the LDA, then that itself is an exemption from FARA registration. And that is a benefit to parties who qualify for LDA registration because the disclosure requirements under the LDA are less demanding than under FARA. So let's talk about these two commercial exemptions because, as I mentioned, in many instances, we as lawyers represent business entities. Most law firm clients are business entities and might not seem to trigger FARA, although many of us as criminal defense lawyers represent individuals too. Bona fide trade or commerce, broadly defined, includes the exchange, transfer, purchase, or sale of commodities, services, or property of any kind. In essence, it will cover practically any type of business activity. This prong of the commercial exemption is not available for political activities. And notably, the term private, which is part of the definition, can be applicable, even if the foreign principal is owned or controlled by a foreign government. It could be a state-owned enterprise, for example, so long as the activities do not directly promote the public or political interests of the foreign government, not further defined. And you can see, obviously, the tension between this characterization of what can be private, but the constraint on whether the activities directly promote the public or political interests of the foreign government. Activities not serving predominantly a foreign interest reflects the second prong of the commercial exemption. This exemption is available even if the U.S. agent is engaged in political activities on behalf of a foreign corporation, even if it's owned in whole or in part by a foreign government, if it's directly in furtherance of the bona fide commercial, industrial, or financial operations of the foreign corporation, but provided that those political activities are not directed by the foreign government or foreign political party, and they don't directly promote the public or political interests of a foreign government or a foreign political party. So you always have to ask those sort of threshold vetting questions to assess whether the representation of a commercial entity where you're engaged in political activity may nonetheless require FARA registration. And here are some questions at the threshold of undertaking an engagement to evaluate regarding the availability of these exemptions and whether you might have to register on behalf, or your client may have to register on behalf of a foreign principal. You know, are the agent's activities in furtherance of the foreign principal's bona fide trade or commerce? Typically they will be. Or a foreign corporation's commercial, industrial, or financial operations. Those typically are not hard to satisfy. Other know your client questions can be harder to get ground truth on when you're representing a foreign party. You know, are the activities directed or controlled by a foreign government or foreign political party? Is there a hidden hand? Is there a hidden financing of these activities? Or are there indicia of direction or control that may not be visible on the surface? Do the activities directly promote the public or political interests of a foreign government or foreign political party? That can be a more subjective evaluation if there isn't a direct communication that the agent of the United States do this explicitly on behalf for public or political interests of a foreign government or foreign political party. So let's talk about how FARA can apply to us in our law firms, because you know, we think that simply because we're lawyers that we somehow don't come within the scope of the statute, but that's not correct. And so it's important for you to understand how we as lawyers can still come within the scope of FARA ourselves. The exemption for legal representation is narrowly framed and it's narrowly construed by the Justice Department. By statute, the exemption is available only for legal representation of a disclosed foreign principal, be for a court or a government agency, but there are exceptions that limit that availability. The exemption is not available if the legal representation and the activities of the lawyer or law firm includes attempts to influence or persuade agency personnel or officials other than in the course of judicial proceedings, criminal or civil law enforcement inquiries, investigations, or proceedings, or agency proceedings required by statute or regulation to be conducted on the record. So if you are engaged in attempts to influence government officials other than in those specified types of activities, this exemption is not going to be available to you. There are regulations, FARA regulations that on their face purport to clarify the scope of the exemption. I'll leave it to you to decide whether you think it provides the clarification that we as lawyers would seek, but the regulations do say that attempts to influence or persuade agency personnel or officials other than in the course of judicial proceedings, criminal or civil law enforcement inquiries, investigations or proceedings, or agency proceedings required by statute to be conducted on the record shall include only such attempts to influence or persuade with respect to formulating, adopting, or changing the domestic or foreign policies of the United States with respect with reference to the political or public interest, policies, or relations of a government of a foreign country or a foreign political party. So if your representation or advocacy comes within one of those categories, this legal exemption will not be available. What types of activities by lawyers could cause us to stub our toe on FARA and be required to register? Advising, these are examples, not an exclusive list, but advising a foreign principal on public relations activity in the United States concerning a policy issue, affirmative activities to influence U.S. public opinion, trying to seed news stories, for example, on behalf of a foreign principal, outreach to policy level U.S. government officials to intervene in a matter, communicating or meeting with U.S. government officials on a policy issue for a U.S. company's foreign affiliate, advising foreign companies on how to influence U.S. government policy. Those are just examples of some of the ways that we as lawyers can exercise representation, but be outside the scope of the exemption. Here are some examples where the Department of Justice has deemed that the exemption for legal representation is not available. Is available. These are examples where the department has deemed the exemption to be available. Representation in civil litigation or a private arbitration proceeding, even on behalf of a foreign government. Representation in an investigation or enforcement proceeding by the Department of Justice or by another U.S. government agency. A request to the Office of Foreign Assets Control at the Department of the Treasury to stay a sanctions designation of a client to enable advocacy, a presentation of advocacy of information and documents to OFAC. A request to the Bureau of Industry and Security at the Department of Commerce to remove a client from the entity list because the department assessed that that was operating within established civil administrative procedures and so did not even come within the ambit of FARA. Conversely, here are some activities where the department has assessed that these legal activities did not even come within the scope of the statute. Applying for an OFAC license pursuant to established and routine administrative OFAC procedures. And in another case, an engagement with a foreign government ministry to improve its international ranking, including activities to conduct public records research in the United States, interviewing international thought leaders, and presenting an analysis and recommendations to a foreign government. Here are some examples where the Justice Department has determined that the legal exemption is not applicable. Efforts to shape public opinion on behalf of a client, even with respect to investigation or criminal prosecution or other litigation. Examples of press releases or coordinations with a public relations firm. Sometimes we as criminal defense lawyers engage in reputation management on behalf of a foreign client, and that can sometimes stray into areas subject to FARA. Contact with or lobbying of news media or special interest groups or NGOs. A case where the agent was lobbying the U.S. State Department to waive a rule precluding courts in one country from enforcing foreign tax laws, even in a circumstance where that activity was adjacent to civil litigation, which in and of itself would have been within the exemption. And in another case, the department determined that activities by a prominent U.S. law firm to persuade leadership of the Department of Justice to support a continuance in a criminal case on behalf of a foreign government that was not a party to that criminal case and for reasons concerning foreign policy and relation matters. So those are just some examples where the department has determined that a lawyer or law firm had an obligation to register. Some best practices for lawyers and law firms in particular to abide by, to ensure that they have an understanding of what the thresholds for registration are and what their obligations to disclose later will be. And this is especially true in the wake of the Justice Department's resolution of a criminal investigation of Skadden Arps, where the settlement agreement with Skadden makes clear the department's insistence on a FARA compliance program. Many law firms are now instituting or have in place FARA compliance programs, and you should think of them similar to the types of industry compliance programs that we as lawyers urge our clients to institute in other regulatory spaces like export control and sanctions, for example, or FCPA, just as we would in cases of those types of compliance programs. Employees at law firms, lawyers, there should be internal training for new hires. There should be periodic refresher training on FARA. There should be internal intake assessments when you are onboarding a new client. If the facts presented reasonably raise questions about whether FARA might apply, I would think broadly, anytime you are onboarding a foreign client, whether it's an individual or a foreign business entity, you should undertake at least a threshold FARA assessment and understand whether you have any obligations or exposure with respect to FARA. Your compliance program should also provide for some sort of issue resolution when questions pop up with respect to what needs to be disclosed or any other obligations you may have as a registrant. Someone should have principal responsibility for addressing those issues. Someone needs to be sort of the point of contact, and it could be, as I say in the last bullet there, a FARA gatekeeper, someone who is sort of the designated quarterback for all things FARA with respect to an engagement that you have determined is registrable. So let me talk briefly about what obligations you have if you are obligated to register under FARA. I mentioned before that there is an obligation to register at the very beginning, and you'll be filing a, come back to this slide here, you'll be filing a registration statement that requires initial disclosures and that are pretty extensive in and of themselves. I don't have a slide included here, but just to give you a brief idea of what those initial obligations are, you'll be identifying and providing details regarding the foreign principal, and including any relationship it has with a foreign government or a foreign political party, points of contact in that foreign government or political party. You have to provide a copy of your engagement agreement with a foreign principal. And as lawyers, that makes us particularly uncomfortable to be publicly uploading to a government website a copy of our engagement agreement with our clients. You have to describe in some detail the activities the registrant will engage in for the foreign principal, including a description of any political activities that you'll be engaged in. You have to describe now any work you did for the foreign principal before even registering with the Department of Justice. You have to identify and describe any receipts from that foreign principal, any payments by that foreign principal, any disbursements you made on behalf of the foreign principal beginning 60 days prior to the date of obligation to register. You have to describe and specify whether you're going to be disseminating any informational materials as part of that engagement and through what means and to whom within the United States. And importantly, be mindful that the registrant has to certify, subject to 18 U.S.C. 1001, which you're all familiar, and the penalty of perjury, that the contents are in their entirety true and accurate to the best of the signatory's knowledge and belief. And in circumstances where we are advising a client who is about to register, it imposes an additional premium on us to ensure that everything they're telling to the department is true. Where you are working as part of a law firm and other partners or associates are working on an engagement that requires registration, everybody in essence carrying out that engagement other than paralegals or clerical personnel or administrative personnel have to register as short form filers, and they will be filing their own separate registration statements, and their disclosures can be invasive too. The statute requires the disclosure of personal residential addresses, which the Department of Justice has recently, it's last week, reaffirmed that these individuals have to disclose. So that's just a brief thumbnail sketch of the initial registration disclosures. Once you become an agent, if you are disseminating informational materials within the United States on behalf of the foreign principal, you have to file them within 48 hours with the Department of Justice. Sometimes, pursuant to consultation with the FARA unit, they are amenable to other accommodations, but you need to work out those accommodations with them. What are informational materials? Well, it's broadly defined in essence to mean practically any medium by which content is disseminated on behalf of the foreign principal within the United States. So here's the definition. You can see how it harkens back to a day where we still use the term motion pictures, but I would think of it broadly to include in essence any content the agent is disseminating on behalf of the foreign principal within the United States. Another requirement that really goes to the heart of FARA, which is a disclosure and transparency based statute, is that anything that comes within the definition of informational materials, when it is disseminated in the United States on behalf of a foreign principal, must include what is described as a conspicuous statement, which states that the materials are distributed on behalf of the foreign principal and that additional information is on file with the Department of Justice. That has to be embedded within the content of that of those informational materials. And this requirement applies not only to printed content, but to social media. So tweets have to be accompanied by a conspicuous statement. Web pages operated on behalf of a foreign principal, if they come within the scope of the statute, have to have, at least on their landing page, a conspicuous statement. Speeches on behalf of a foreign principal have to be preceded at the beginning by a conspicuous statement, op-eds, and so forth. So be mindful of this requirement. If you are an agent of a foreign principal, you're not only going to have to file an initial registration statement, but approximately 6 months after the initial registration and approximately every 6 months thereafter, the agent has to file a supplemental disclosure statement. And there the agent has to disclose the activities and services that the agent performed for the foreign principal during the preceding 6 months, including any political activities. There is required some specificity as to the conduct of political activities. You'll see if you go to www.fara.gov, you can see how public relations firms and lobbying firms will include lengthy addendums of emails to congressional staff, phone call citations to staff members, for example, documenting and chronicling political activities they performed. You have to disclose payments that you received from the foreign principal. You have to disclose disbursements made, so any payments made to third parties, subcontractors, vendors, in furtherance of the execution of that engagement have to be disclosed. The name of the party to whom the payment was made, the amount of the payment, the date of the payment, information regarding the dissemination of informational materials has to be disclosed. And one other thing to be mindful of, you have to confirm that informational materials not only were filed with the Department of Justice pursuant to that 48-hour rule, but that they were labeled consistent with the conspicuous statement requirement. So as I mentioned, we're now living in a vigorous, aggressive enforcement era at the Department of Justice. This enforcement era began in early 2015 while I was still serving as chief of the Counterintelligence and Export Control Section. It has surged further since then, and it's fair to say that the Justice Department's enforcement of FARA now is the most aggressive and intense it has been in decades. It is manifested in certain ways. The appointment, as I mentioned at the beginning, of a new deputy within the Counterintelligence and Export Control section who has singular responsibility for overseeing FARA. Anecdotally, we know that the department is issuing more letters of inquiry. These are letters the department sends to parties when it has some question or reason to believe that someone may have an obligation to register, not infrequently triggered by news stories or the FARA units combing through LDA filings. We know also that there are more audits these days than before, and anecdotally that FBI agents are participating in those audits. Anecdotally, we know that the department seems to be manifesting less flexibility today on redactions. The filings, I'll mention that when it comes to filings by law firms or lawyers, we want to redact as much as we can because many of us review those engagement agreements themselves as privileged. The department has shown some flexibility to redacting our hourly rates, but in cases where our engagement agreements specify a total amount, let's say a flat fee, for example, the department has not been amenable to redacting those gross amounts. And when it comes to describing the nature of the engagement, the services and purpose of the engagement, there has been inconsistent accommodation by the department to that. That's something that has to be often negotiated with the department. There have been more deficiency notices for filings when registration statements are made, initial registration statements. The department reviews them for compliance with all the multiple registration requirements, and if the filing is found to be deficient, a letter will result, and the filing is not deemed complete until those deficiencies are corrected. And by law, the agent is not to begin performing any services on behalf of the foreign principal until the deficiencies are corrected. In the last few years, the department has been making more criminal referrals, undertaking more investigations of potential criminal violations of FARA, and as seen early in our presentation, there have been more public criminal prosecutions of individuals for violations of FARA, including attorneys. I also mentioned before that the department dusted off a year or two ago its authority to bring civil injunctive actions for the first time since 1991. This is authority that empowers the department to seek an injunction by a federal district court ordering a party to register under FARA. And that's what the district court in the Southern District of Florida did in the RM Broadcasting case. What are the potential consequences of violating FARA? Well, as we talked about, criminal prosecution, which can result in either imprisonment or a criminal fine. Again, civil litigation by the Justice Department to pursue injunctive actions to obtain a court order requiring an agent to register, and reputational harm to clients. As bad as it is for some parties to be characterized as foreign agents, quote unquote, because they believe that's stigmatizing, it's even more stigmatizing to be publicly the subject, if that information becomes public, that they are subject to a criminal investigation for violating FARA. The criminal penalties are stated here: 5 years of imprisonment and a $10,000 fine for a willful violation regarding a failure to register or a false statement or omission of a material fact. When it comes to FARA, willfulness is defined essentially the same way it is in areas such as violations of export control and sanctions laws, the violation of a known legal duty. In essence, if you knew you had an obligation to register under FARA and you failed to register, you are subject to being determined to have engaged in a willful violation. Misdemeanor penalties only up to 6 months and $5,000 for a willful violation regarding other types of conduct, a failure to include a conspicuous statement and informational materials, failure to disclose a foreign principal agency to a U.S. government agency or Congress if you're testifying, deficiencies in a registration statement. If you're proceeding with activities under an engagement without having corrected these deficiencies, you're subject to a misdemeanor. And if you engage in political activities on behalf of a foreign principal where there's a contingent fee, you are subject to a misdemeanor. So that's it for today's FARA 101. I will be bringing to you shortly another episode of this, focusing more on the department's FARA enforcement surge, recent criminal prosecutions and other enforcement actions, and lessons learned from those enforcement actions. So thank you very much for your attention today, and I look forward to being with you again soon. Be well. Thank you.